Hello, everyone, and welcome to the Woodstock Chamber of Commerce Learn With Us series, where we are doing workshops hosted by our local members who have some insight to share about their industry. And today we are excited to have Wes Mazer join us from Mazer Safety to share with us Safety Smarts. It's a 2025 update and must knows about due diligence. Good morning, Wes. How are you?
Good morning, Mike. I'm great. Good morning, everyone.
Well, thank you very much for being with us. Wes, you have over 25 years experience, and you're a part-time professor and instructor with Conestoga College and University of Toronto, former safety inspector in both Northwest Territories as well as Nunavut, an expert witness and report writer and investigator for OH&S litigation, and a Canadian registered safety professional. You have quite the repertoire.
Thanks, Mike. It sounds so fancy when you hear it, but it's all over time. But yes, that's me. And today is you already know I'm coming to you from downtown Woodstock, the other side of my business, which is selling cheese. So yeah, like to be busy.
Well, we can certainly appreciate that. Thank you very much for joining us today. I will pass the baton your way so you can share with us.
Super friends. Let's just get right into the presentation here. So good morning, Latia Ann and Delaney, if I pronounced your names right. Thank you very much for joining. And Mike, thank you for that amazing introduction. When Mike and I were talking about something that we could put together, we thought, you know what, let's make this a little bit more informative, a little bit interactive. So please, if you have any questions or comments, just come off mute, jump right in. If you're logged right into the window, I learned a little Zoom trick a couple of years ago that if you push and hold the space bar, kind of like a walkie-talkie, if you push to talk, you can push to talk in your space bar as long as your mouse is inside of the Zoom window. It's kind of a fun little thing. So yeah, you don't have to go fumbling with the mouse kind of thing. So we're going to talk a little bit about updates. So what's new, what has changed in the last couple of years, but what is becoming or has become legislation here in Ontario now. What are sort of some responsibilities to consider, especially folks that are in a management role or the role of an employer or director of a corporation. And there's this term and concept out there called due diligence being used as a defense. So I want to sort of unpack that a little bit. I'm actually currently retained by two different law firms working on two different fatality investigations. One, the Ministry of Labor is currently active in their investigation. The other one, the Ministry of Labor concluded their investigation, and now they're kind of working out sort of lawsuits and that sort of thing. So in case number one, I'm doing an active investigation third party. And what I'm looking for is any element of due diligence defense potentially for that employer for its ownership and officers and directors of the corporation, as well as other key stakeholders that may be involved, such as supervisors. And the other one's a little bit different. So I won't get into the weeds on that one, but we're ultimately looking for due diligence. So thank you for joining. I'm just going to do a quick introduction. Mike already kind of did that. So Mike, thank you very much for all that stuff. That's when I had some hair. I had to wear a hard hat for a year over at Cami when they were doing the battery factory a couple of years ago. So I thought, you know what, I'm just going to get the clippers out because it was just coming out in clumps. I'm like, it's going, it's gone. So and I and got some glasses in between as well. So I don't know if I look better or worse, but that's certainly a younger looking fellow right there. So, what are we going to unpack this morning? First, those highlights as we were talking about, but just and responsibilities and due diligence. And then we're going to have a little chat about what are some strategies. So, what are Wes's tips and tricks for you to help maintain compliance and improve safety culture at your business? A couple of things to keep in contemplation here. Why does staying current really matter? First of all, it's living and breathing. So, occupational health and safety is dynamic and it is always evolving. Now, this stands for OHSA, which is the Occupational Health and Safety Act. It is always changing. The policy branch at the Ministry of Labor is always making recommendations for updates and tweaks, and that's based on industry and stakeholder engagement and feedback. And then they basically go through the Minister's office to potentially introduce new legislation and changes to the law, changes to the regulations, and just overall policies on how they sort of implement and enforce their programs. Second is the legal obligations that are tied to current standards. I just did a half day sort of annual safety meeting with a sheet metal company over in the Kitchener Waterloo area. And I sort of wrote on the whiteboard, I said, folks, safety is important, right? They're like, oh, yeah, it's important, or whatever, rolling their eyes. I said, but it's also the law. This is something that people don't often think of when it comes to occupational health and safety. It's just like driving a vehicle. Everywhere we drive, we're under essentially the Highway Traffic Act. And if we break the rules of the road and if we are seen by an officer, we're going to be pulled over and we're likely going to be charged. So when we find things in occupational health and safety that happened or didn't happen, well, then you have safety officers that are going to come and they have their green book, if you will, of list of things in the act and the regulations, and they're going to judge us as to whether or not we were in compliance. Either we were in compliance or we were not. So one of my favorite sayings is safety isn't just important, it's also the law. Another one of my sayings, and as you can tell, I'm sitting on a Star Destroyer right now, is to quote Jedi Master Yoda, do or do not, there is no try. Like, oh gosh, he's one of these guys. Yeah, I'm a geeky kind of fellow when it comes to stuff like that. But the reason why that means a lot to me now in 2025 is a company is either in compliance with the act and the regulations or they're not. There is no trying to comply. It is legislation. It's literally black and white. Same thing with being safe. So are your workers safe or are they trying to be safe? Well, you're either safe or you're not safe. There's no trying to be safe. So I really try to bake those into mindsets when I travel and I do all kinds of things across across Canada in terms of investigations and training. So it's very interesting to hear perspectives of folks. But and the other thing here is failing to adapt. So looking at an increased level of risk and liability as well. So we got to stay current. We got to know what the trends are, and we're going to kind of unpack that for you. So what is coming up? What is recent? What's happening this year? I don't know if you've heard this or not. If anybody participated in the WSPF sessions last year or this year, you may remember this. But essentially, the fine for any individual person, you, me, workers, the boss, doesn't matter, could be fined now to a current of $500,000 per offense of the Safety Act or its regulations. And it was $100,000, so they quintupled that. That is a huge increase. So maybe if anybody's listening, participating, sipping on morning coffee, tea, or water, any contemplation in your mind, why? Why would they go from $100,000 to $500,000 for any person? What's what's the point? May or may not have anybody joining in. Let's see, Anne, what do you think?
Um, I'm guessing that people just aren't compliant. I'm guessing that, maybe they need a harder slap on the wrist.
Yep, and that's exactly what it is. It is sort of incentive in a very monetary form. Is exactly that. In fact, back when I started in the industry, the maximum fine per person was $25,000. Then they bumped it up to 50, and then it went up to $100,000 just a couple of years ago, and now it's at that $500,000 exactly for those reasons. Same for corporations. Corporations, when I started in the industry, it was $500,000 maximum fine. Then it went up to 1.5 million in 2017, and now in the last year it has jumped up to $2 million per offense. Now, something that is new to the act in the last 12 months is a director or officer of a corporation can now be fined personally up to $1.5 million. So this one I'm going to unpack just a little bit deeper because I think to your point earlier is that people just weren't getting it. Well, officers and directors of corporations weren't quite getting it either. So when the inspectors would do their investigations and they would go to their management would review with the Ministry of Labor's legal, which is the Crown Attorney of Ontario, they would find on quite a few occasions that the workers were doing what they could do, that the frontline supervisors and managers were doing what they could do, but they were in a position, I'm going to try not to use big terms today, but I call it a position of self prejudice. And what do I mean by that? Well, especially those supervisors and managers, there's very strict law that says that they shall ensure worker works safely, uses the equipment, and if they don't, then that supervisor gets in a lot of trouble. Well, in quite a few cases, the supervisor did not receive the budget or the support from the people in control of it, which is the officers and directors of the corporation, whether it's an officer and director like me. So, like my other business is Cheesy Cow Company in Woodstock. Well, I am an officer and director of that corporation. So is my partner, Sarah. So if we decided not to give our staff WHMIS training and they got injured or made sick or worse because of chemicals that we use to disinfect, we could be liable ourselves of up to $1.5 million, depending on the severity. So then we have like a larger corporation where you literally have a board of directors. And like the board of directors for a bigger corporation, they basically review all the budgets. So all the department heads bring the budgets to them, they present them, and they decide yes, no, or they take their pen out and they stroke stuff away. In some circumstances, officers and directors have said, we're not buying the up-to-date working at heights equipment this year because we don't have the budget or we don't want to spend the money on it. Well, then it was implicated. So there are some reasons there. And I think the underlying point here as well is that in each circumstance, it could also include up to 12 months imprisonment. It could be fines or imprisonment or both. Now, something that we don't really dive into a lot in this presentation is the Criminal Code of Canada. But safety officers and inspectors do come to workplaces with quasi-criminal investigative powers and techniques. So they're always contemplating in their mind when there's been a serious workplace incident, was there any negligence involved in this? Right? If you can imagine a director or an officer making an arbitrary decision not to provide the required safety equipment or the required safety training, that's a big deal, and that is negligent. I referred earlier to 2 fatality investigations I'm working on right now. The first one, I absolutely believe that criminal negligence charges are coming for the supervisor and possibly for the CEO of the corporation. Right. And I won't get into the details on that because it's live, but it's very, very, very serious stuff. Okay. Something new. So there's an expanded definition of workplace harassment or workplace sexual harassment. It now includes virtually through the use of any information and communication technology in both circumstances. Okay, so it's still the same definition. Of course, a vexatious comment or conduct in a workplace against a worker that is known or ought reasonably to be known as unwelcome. And sexual harassment is the same, plus it includes because of their sex, their orientation, their gender identity, or expression, or where that course or conduct, again, is reasonably known to be unwelcome, or it's a sexual solicitation or an advance where the person sort of making that solicitation or advance is a position to either, confer, grant, or deny a benefit or advancement to the worker. So in layman's terms, offering, an advancement or promotion or a raise to somebody for something sexual. So it's very important that staff understand, and that anybody here, I don't know what your role is in your company, that, don't engage in that conduct to begin with, but certainly not put it out there through text messages, emails, social media, any instant messaging apps or otherwise. It was not acceptable, and it is used for investigations. And now you can see it's baked right into legislation. Any thoughts or questions on that?
I'm actually surprised that it hasn't been included a little sooner, considering
Mm-hmm.
how far, especially things like social media, have come over the last 20 years. It's uh, so yeah, somewhat surprising that it's only just being included now.
Yeah, that's a good point, Mike. And I like to say that the Safety Act is written by lawyers for lawyers because of lawyers. So this was updated by lawyers for lawyers because of lawyers. So in other words, something was tested, there were charges made, but because the definition originally didn't include this means, it was not enforceable. So policy change, new definitions or broader definitions. Yeah, surprising. I agree. I agree. So guess what, folks? I don't know if you heard this earlier from WSPS, but you are now allowed to have electronic copies of your harassment and violence policies, your joint health and safety committee names and contact information, your occupational health and safety policy statements, so long as workers can access it. Okay, so workers need to know where and how to find it. So, in other words, I can't just have it on my MacBook. Oh, I've got electronic leads on my MacBook. Well, no, there has to be an electronic means of staff to access that. So maybe an intranet, or you have like some sort of a computer terminal at work, but it is finally there. And there are like companies that are kind of sophisticated and up further into the technology where they want this, and it's about time. I mean, the industry has been asking for this for about 20 years now, right? Why do we have to have a physical piece of paper, right? And so there it is. So these are just the various sections that talk about what can be posted, and I just listed them to you, so I don't have to read them out to you. But so that's fun and new. Yeah, sorry, Mike.
No, that's quite all right. If I could clarify something too. So, does this mean that you do still have to have a physical copy posted? You just can also have a digital one, or can you move fully digital?
You can move fully digital so long as all of the staff know how to access it. So it has to be readily accessible by all workers in the workplace. And the workers have to know how to get it. So there's a little bit of communication and or training and orientation about it, or signage, right? So what I've seen a couple of companies do already, Mike, is they do a QR code and they have it on their board. So instead of a safety board, and I don't know how big your safety board is. I was just thinking about this the other day. I need to get a bulletin board for the new shop. And the amount of things that had to be posted, you could easily do like a 4 foot by 6 foot or 6 foot by 8 foot board with all these safety postings. But now you can use a QR code and bring them to the act, to the regulations, to your policies and procedures. Yeah.
Smart.
So yeah, absolutely. We're getting there one at a time. I think I'm quick. This one's fun too. Application to teleworks. In other words, remote work or working from home. So now, except as it's prescribed and subject to the conditions that sort of limit something, it doesn't apply to work performed by the owner, occupant, or servant of the owner or occupant in or about a private residence or the lands and appurtenances used in connection therewith, so like the shed and the garage. Okay, but despite that, this is what's new. This act applies to remote work or telework performed in or about private residence or the lands and appurtenances used in the connection where we're in. So in other words, it's like it doesn't apply, but it does apply. So what the Ministry of Labor has done is they've added this language in, because if you have ever worked from home, or if you have staff that work from home, the employer's sort of disadvantaged because we don't know, are they sitting down in a proper chair at a proper workstation, ergonomically speaking, or are they lying on their bed doing their work, or the couch, or whatever the case may be. There's no way that we can guarantee the health and safety of an individual at their private residence, but companies can impose some policies to say you need to make sure that you have a clear escape route, that you are using an ergonomic workstation. Companies that go down that road may also be required to help provide such equipment. So it is a bit of a slippery slope that way. But I just wanted to bring this to your attention because now basically the ministry has given kind of like a warning shot to say the act actually is applicable to. Okay, which makes sense, I think, to a certain degree. Washroom facility requirements. So in the construction industry, there always had to be records regarding washroom facility cleaning. Now it applies to everyone. Why? Because employees have been complaining for decades that the washrooms at work are disgusting. How many Tim Hortons have you gone in? And if it's not a separate washroom for the staff and they're using the same washroom as the public washroom, it becomes complicated. But this now means that we have to have physical copies posted in a conspicuous place in or near the washroom, and it will show workers that it has been inspected or maintained. So now, as we get ready to move into our new shop here downtown, for an example, and laser safety will be in the back of the shop, by the way, so we're moving in together. But it needs to be there, and we have to get the staff on a routine where we're inspecting it at certain times per day. You'll see this in McDonald's, like in other fast food restaurants. This has been a practice forever, where they go in and they sign, and if there's an issue, so that our staff knows, so that we can, draw our attention to it. So I think it's a good, not just practice, but now it's law. Okay, so not just construction sites, but it's everywhere now. So where does this come from? So under the Working for Workers Act, which started in 2024, which is these initiatives that you see, plus many more coming, it includes stricter PPE, so personal protective equipment requirements. That's going to help support women in trades, ensuring that equipment is appropriately sized and fitted. But it's really aiming to help enhance safety and inclusivity in the workplace. What I was at that construction site in Ingersoll, um, we had harnesses on certain freight that had to be tied up every day, all day long. And I'll tell you, one of the female employees, she was given a men's harness. It was extremely uncomfortable, didn't fit right, and it was a bit demeaning. Number one, the way that it fit, but number two, it also wasn't necessarily safe because of the way that it fit. It wasn't um, contoured enough to the body that it could actually pose an issue. So I'm personally happy to see this. Now, if a workplace doesn't have more than one potential gender working there, okay, but it is required. So if you do, then there needs to be that equipment. So not just accommodating somebody, but it's actually coming into effect now that it is legally required. So I just did a health and safety program update for my sheet metal contractor friends in KW, and their program now includes this. Now they've never had a female sheet metal worker on within their company yet, but it's baked in there just in case to say, folks, here's what's required if you do. Okay. Just like buying different sizes, right? If I need a harness, I probably need an XL or a double XL, where somebody else might need a medium. So it's really not putting anybody out. So switching gears here to mental health and workplace well-being. So again, under this act, right, Working for Workers Act, there is now lots of investment in worker health and safety, including mental health initiatives. And it really does reflect a growing recognition that mental health and well-being and occupational health and safety is really important. It does affect everybody all the time. So how does it impact? Well, there's some key workplace impacts. There are new sectors that are included. There are broader definitions now in the act of who is a worker and who is an employer. Something that I want to mention is, like, I right now have two different trades helping us at our store. One is electricians and one is a plumber. Okay. I am contracting the work to them because I don't do that work. Okay. I'm not a certified electrician, but it's still at law is an employment contract, right? I'm employing them for services in exchange for money. So I do broadly have responsibility for them in terms of health and safety. Yes, they might have their own safety policies and their own safety training. That's great. That's convenient. But I still have an overall responsibility to make sure that they are following the acts and the regulations. Even more important when I have the plumber, because the plumber is independent. They don't have staff. The electrician has a couple of staff. So I do want to bring that to your attention. It is important. It's really little known. And sometimes when folks get themselves into trouble inadvertently, whether it's at work or let's say that you're hiring contractors at home, you are hiring them essentially, even though it's a contract at common law and employment law, they are still seen to be your worker, because a worker is anybody who performs work for an employer, whether it's directly or under contract. So, it's always the devil's in the details, as they say when you read the legislation. Again, it was written by lawyers for lawyers because of lawyers. So it's a really broad capturing of those terms. There are some new notification and reporting rules as well. A lot of them are pretty much the same, but in the construction sector, for example, in the industrial sector, there were some differences between reporting when a worker came in contact with live electricity, and now they've kind of leveled it up where it's the same in both industries. Before in construction, you always had to report it, which is the same, but in industrial, you didn't have to, which doesn't make any sense. It's still risk, right? I mean, coming in contact with live electrical is coming in contact with live electrical. So the compliance requirements, well, there's specific changes to training requirements as well, and some of you may be up to speed on that. New posting and signage rules. There's also some revised deadlines for compliance documentation as well to be aware of. Um, just going back to enhancing the rights of workers. So the right to refuse unsafe work on the ministry's website is a little bit more clarified now, and it's expanded. Here's the reason why: is many employers were taking for granted that workers were not saying the words. So let's just pretend that Mike was my boss, and I say to Mike, "You know what, Mike? That I'm really not comfortable doing that job. Like, I really don't think I should be doing that job. I don't think it's right, and I think I might get hurt." Mike says, "All right, Wes." And Wes walks away, and Mike says, "Hey, Jill, can you please do that job?" Well, I essentially just refused to do the work. But then Mike says, well, he didn't actually say he was refusing unsafe work. That's semantics. So the semantics are being removed. If it is the intention, right, or ought to reasonably be known that the worker was refusing to do unsafe work, and regardless of the words that they did or did not use, the intention is there. Okay. Also, something new is enhanced protection for whistleblowers. So, folks that are going to blow the whistle on unsafe work practices, training, all the above. Right now, we do have reprisals are prohibited under our Safety Act. So that means if you exercise your right under the law, that you cannot be reprised, punished, fired, threatened, otherwise intimidated. However, this goes a little bit beyond that. So if call the whistleblower hotline, if you call the Ministry of Labor or workers call the Ministry of Labor, even though it was implied that they don't get reprised, this expands it a little bit more. And the employer's response to protocols are a little bit tightened as well. So just zoning in on the responsibility. I often ask my students, or when I'm doing training with adults, I'll ask them, like, so, hey, we understand that health and safety is a shared responsibility. Health and safety is everyone's responsibility. But then I will ask folks, well, who's the most responsible for health and safety, or who is ultimately responsible for health and safety? And then I always land on that employer. The employer is, and again, going back to the officers and directors of the corporation, they're the decision makers. They hire and fire, they decide whether or not you get vacation or a raise, right, or the training. So ultimately, yes, I agree, and I certainly teach that it's an internal responsibility system. We want everybody to be at the table, but at the end of the day, the employer makes that decisions, right? They set schedule, they hire, fire, all those good key points. So the Ministry of Labor does different courses throughout the year. It depends what it is. Like right now, they're getting geared up for summer students. So I've noticed here in the city of Woodstock, we have students back from university. They're out working for parks and roadworks and stuff as well. So usually around this time, between April and May, they will do a blitz. So they will show up and they will check in on young and new worker safety, as an example. Violations for last year, a ton of workplace harassment shortcomings. So not having policies, or in particular having training in place for staff. So inspectors have really been enforcing that quite a bit. That's common across all industries. Construction sector, it's still falling from heights, and it is being killed by reversing vehicles, aka dump trucks, where there was no spotter or somebody to signal them when they back up. So that is a big one. Penalty trends, fines and stop work orders. There's actually more. And so I don't have the stats in front of me. I don't like boring people with numbers. We see them all the time. But what I can tell you is that there are more fines and stop work orders than ever before. Something interesting, weird, magical, I don't know what to really call it, since COVID is that people have just really stopped being proactive, and so there is a lot more reactive enforcement taking place. You may not see inspectors as often as you used to because they are responding to issues all the time. They just simply don't have the time or as much time as they did to do the proactive things. So that is interesting. All right, a couple of case studies, folks. And we're a little bit faster just because there's not a lot of Q&A and stuff this morning, but that's okay. Case number one was a misled. I was talking to somebody the other day, a witness, about not misleading the inspector. Missed inspection. So in other words, there was a serious injury that occurred. I'm not going to mention company names here, but upon investigation, it was determined that the piece of equipment that failed and ultimately seriously injured the worker, that there was not an inspection on it. So this is one of those types of machines where you're supposed to inspect them before use. The inspection had been missed. If it had been done, it actually would have caught the deficiency and the worker would not be harmed. And the second case was no documentation. This is super important from a due diligence point of view, friends, is you document everything. Any training that you provide workers, document it. Any instruction that we provide workers, document it. Any learning opportunities, coaching opportunities, or progressive discipline issues, anytime you see a worker and have to speak to them because they're not wearing their safety glasses or doing something else that perhaps was unsafe or not following policies, procedures, or perhaps even the act of the regulations, document it. If there is not, what's the term called? It's called the Philadelphia lawyer. If it's not in writing, it didn't happen. I forget what they call them. But that is so true when things go to court. If it ain't in writing, it didn't happen. So it's got to be documented all the time. And I hate doing it, but like, listen, friends, like we this worker is not with us anymore. But you know, I came to the tea shop once on the weekend. It was a Sunday, and we're closed on Sundays during the off season, and it was just left in a really poor condition. Like it was not clean, it was not sanitary. There were knives left out where they shouldn't be. Something was left in a quasi unsafe position as well. So I thought, you know what, I can just get it all cleaned up and move on. Well, I did, but I also emailed the worker with photos to say, hey, we really appreciate you, but this is the expectation. This is the condition that we saw things in. This is why it's not okay from a food safety or public health point of view. Nothing was like gross or going to make anybody poison. Don't take that for a mistake, but it just wasn't clean, right? Like we had to, sanitize everything. And so when you see that the counter wasn't wiped off, well, then, so, but I always document everything. Even if it's just a friendly reminder, I always document it. If you don't have that history and if something happens, you certainly will wish you had. So a couple of key lessons and takeaways. Let's talking about this due diligence thing. So basically, due diligence, very simply, is taking all reasonable precautions. So what is reasonable? Well, the reasonable person test in the courts is very simple. It's doing what a reasonable person would do or not doing what a reasonable person would not do. Very simple, right? Second here is due diligence is a legal defense under the Act. So back in the 1970s, there was a case law setting thing, and due diligence was born when the judge said that, listen, everything here is absolute liability. And what happened is I believe it was the city of Sudbury. They had an accidental discharge of contaminant that went into the waterway, and under the environmental legislation, it's just an absolute liability. It's automatic conviction based on the event, not whether or not you did anything to try to prevent it. So in that case, the judge created a new type of liability, which was called strict liability. So in other words, hey, if you can prove to the courts that you did everything reasonably in the circumstances to prevent that from happening, and despite all your best efforts, something still happened that was not foreseeable or was out of your control, then that will be a defense, aka due diligence. And so they did. So it went to an appeal, it went to a higher level, and at that appeal court or the superior court, whatever it was, due diligence defense was born. So sorry, just got to move our little smiling faces over here. When it applies, So when there are charges, when there's investigations, unfortunately, you can't make it go back in time, right? It's not a time traveling type of defense. It's a snapshot in time. At the time of the incident, the accident, fatality, whatever it might be, what did you have in place? Did you have policies, procedures, and written instructions? Yes or no? And if we did, fantastic. Next question. Did we implement them? Did we provide the workers with that information? Did we give them the training or the communication, depending on the topic? Okay, and all the above, documented, documented. Next is what did we do to ensure the workers understood it and are actually following it in practice out in the workplace? If we can go and see them, speak to them, maybe audit, maybe do an inspection, document it, that's part of due diligence. And then it's to act upon our findings. So really and I learned this back in my Toyota days, it's called PDCA, Plan, Do, Check, Act. The plan is the written policies and procedures and instructions. Doing it, D, is communicating and doing training on it. C is checking it, so going and seeing and speaking with workers and doing inspections and doing audits. And A is acting upon our findings. So either everybody gets high fives all the way around, so everybody's doing a fantastic job, or maybe we have to go back to that policy, procedure, set of instructions and tweak them a little bit. Maybe they were not 100% accurate, or perhaps we didn't have that certain thing in place whatsoever. So it's an opportunity for continuous improvement. Same thing with the training and the communication as well. So it's basically a living cycle of continuous improvement. And although our Safety Act doesn't use the terminology, inspectors do sort of look for that in terms of a due diligence cycle. Any questions or thoughts about that? This is often a commonly heard topic, but not necessarily fully understood. Hearing none, we'll continue on. Oh, pardon me, back up. So we talked about reasonable precautions. So the second fatality investigation I'm working on right now is because of lawsuits. And what I've been asked for is an expert opinion based on industry standards and foreseeability. Would it have been reasonable for the company to rely on the services provided by the third party? That's exactly what I'm looking at right now. But it is based on industry standards and foreseeability. So notice we don't use the term best practices. Usually we sneak in best practices here, but in the world of compliance, best practices is not helpful. The lawyers don't like it because best practices seem to imply that there is a better way of doing something. So they like to use the term industry standard. In other words, what's the norm? What do all cheese shops do to cut cheese? Do they all use knives? Well, actually, no. They only use knives for certain types of cheese, and every other cheese, like 80% of cheese out there, can be cut with a wire cutter, which is a lot safer, right? So what's the industry standard? What's the norm? So you kind of have to, know what everybody else is doing and how does it work. And foreseeability is a thing as well. Not everything is foreseeable, but quite a bit is. Precautions also vary by role and context. What is reasonable? Well, it depends on experience. So I was saying to Mike before we got started live with everybody this morning that my daughter is working at one of the election polls today, which is really good. The poor kiddo has no idea what she's doing, but she's going to learn today, right? So, and then you have people working at the poll where they've been doing it for the last 25 years, right? They've been at so many elections in a row. So it's a great opportunity, but we then, from a reasonable point of view, can't expect a teenager who is brand new to doing the job the very first time to understand what they should say, where they should sit, how they should act, right? They won't know until they've gone through the process. And I believe that is true for everything that we have, every task that's out there. So we often say, oh, young workers. No, no, no. Just anybody new. I like to say the term new workers is we got to make sure that we don't take it for granted. And we can't assume common sense. Common sense is not so common, but it doesn't even really apply in the workplace. What we're talking about is, do folks actually know how to do that job? Something that I had and took away very quickly from our tea shop was a meat slicer. Okay. There is a very interesting way to take it apart and bleed it It scares the bejeebers out of me because I don't want my staff to cut their fingers off, right, or their fingertips off. So we actually said the beans with that. I'm taking it home, right? Unpacked it, disinfected it, took it home. It's in the garage still. And we started ordering sliced meats in instead. Now, is it cheaper for us to do it on site? Probably, but you know, reasonable precautions. I don't know. Mm, yes, we have training on it, but really, so I eliminated the biggest risk in our store. Also, reasonable precautions is not finite. There's not a checklist. It is literally an ongoing commitment. I think people just have to really think about what's in front of them. And if you have to think about whether or not something is the right thing or the wrong thing when it comes to safety and reasonable, then you probably know. Like follow your self-guided conscience in most circumstances, because usually your first kind of thought about it is usually the right one, right? Go with your instincts on it. If it's not, if you think it's unsafe, then it's probably unsafe. I've been to court too many times in my career. And one thing that really stood out for me was back in 2011. This was in Sarnia, where a criminal judge was brought in, and the judge said that you don't have to be. It had to do with a firefighting fatality during training. It was an ice water rescue thing that happened down there. The judge said, because we had heard from like a dozen expert witnesses, we had fire chiefs, paramedics, firefighters, Ontario Fire College people, right? All these people that know everything there is to know about firefighting and training and ice rescue. And the judge said, at the end of the day, none of that matters. I just have to be Mr. and Mrs. Smith walking my dog down the street, seeing what those firefighters were doing that day. And I would know that what they were doing seemed stupid and foolish. There was no reason for them to be doing what they were doing without the proper gear, without the proper safety things in place. You don't have to be a professional career firefighter or teach at the fire college to know that. You just have to be Mr. and Mrs. Smith to understand that whatever that is right there, that looks unsafe. And the judge obviously was quite right. So I found that a very interesting comment from a judge. And it was a criminal judge because they were thinking about convicting the people involved with that criminally after it went through the provincial level. So how do we build effective due diligence? So following that PDCA cycle with a couple extra little icons here, having those written policies and procedures in place is number one. Is making sure that we provide training and we ensure that the workers doing the task are competent to do so. So in other words, they understand the requirements, they've demonstrated to us that they know how to do the job. And in some circumstances, you may need something a little bit more formal. So I think about forklift training. The world of forklift training, you'll get theory, and then somebody is going to go through a checklist with you on the practical component. Another big part of this is knowing what your hazards and risks are. It's huge. Every health and safety system. So there's a couple of terms. One's a health and safety program, which is essentially the binder of paper. But a health and safety management system is what we're really talking about here. All of these key bullet points or all these key icons. And they are intended to be hazard and risk based. So if we understand what could go wrong inside of our organization, that will help us understand what policies and procedures should we have and what kind of training should we provide to our workers. And if they need to wear, now these look like safety glasses, there's the regular glasses, but it'll also tell us based on hazard identification and risk, do we have to wear any protective equipment or not? Documentation and record keeping, of course, I can't say that enough, document. And then doing inspections and correcting things as well. It says corrective actions. It's not the same thing as discipline. It really means putting corrective actions in place for unsafe elements. So how do we see due diligence in action? Real world success stories from some Ontario businesses where they were able to show, and I'm just going to say this to you, in 70% of very serious workplace accidents or fatalities, the Ministry of Labor does proceed with charges because somewhere along the line, a part of the act of the regulations was not complied with. But 30% of the time, they don't recommend charges whatsoever. They're good. The employer demonstrated their diligence. So we don't often hear those stats, but that's what they are. So what worked? Well, in those 30% of the cases, they were very proactive in their training. They had really good records. They were very responsive in doing their inspections, right? So not only did they have the health and safety program, they applied it. And some lessons learned from avoided charges in some circumstances, for sure. Those people would take a big sigh of relief, especially when we see the amount of fines. Something I'd like to ask, and I think we might have lost somebody there, Mike, but um, does anybody, like Mike, yourself, or Lesia, Ann, do you have any idea of what it costs to retain a lawyer? So let's say that your company was involved in a serious workplace accident or fatality. You get a lawyer on board, and to get prepared to say guilty or not guilty. So you haven't even gone to court yet. You're just going to decide in pre-trial. How much money do you think that would cost a corporation?
I think it would cost a lot because, like, for us, we're not for profit. So, so
Mm-hmm.
for us, the cost would be a lot. I don't have the exact dollars and cents, but for us, it would be an arm and a leg and a kidney, probably.
And a kidney. Just throw that in there too, right? Hey, take it away.
Yeah.
Yeah, yeah. As long as we can find a new one, right?
Yep.
Yeah. Mike, what about you?
I would certainly agree. I can't imagine it would be cost effective, but necessary.
So I don't know. Hopefully, you've never been involved in litigation, but if you have to hire a lawyer to serve somebody a notice of claim, you're giving them between ten and $20,000 as a retainer, and that's just to sue somebody. So when you call an experienced lawyer who specializes in OH&S defense, you're talking just to say guilty or not guilty between 25 and $50,000. And then if you decide to say not guilty and you're going to go to court, you're going to retain them for trial, you're going to get that sort of thing going on. An average occupational health and safety trial is 5 to 10 days because of the amount of evidence and witnesses to go through. And you're going to be paying approximately $5 to $8,000 a day for your lawyer. And then the fines, if you're not successful, are on top of that. And as we saw, the fines can go all the way up to 2 million or 500,000 or 1.5 million, depending on the person. It is exceptionally expensive. Now, I know what my rates are, and I don't charge anything like a lawyer, but I can tell you what I'm charging on these two fatality cases. I'm good working a couple of days a week, right? Like just for my part of it, and it's so expensive, and that's just the monetary impact. Um, to see the impact on the workers, on the supervisors, on the owners, it is absolutely devastating. Like people can't think, they can't sleep, they're having nightmares, they don't want to be there anymore. It is just such a terrible, terrible, terrible impact that I do not wish on any business in the world. It's just unfortunately I see it on a common or a lot more often than I should. Thanks for your thoughts on that, folks. So, what are some best practices? Engage. Engagement is huge. Make sure that leaders and supervisors really fully understand what their part is in helping execute health and safety. They are your frontline people and what I like to call our door wedges. They hold the door open for safety, and we really count on them to make sure they're their eyes and ears of the organization when it comes to workers and working safely. That's just to foster a really good safety first culture. So, as I said at the beginning of the presentation, safety is important, but it's also the law. So, we don't want it to be something that is like, oh, it's a pain and oh, but that's just stupid. Well, actually, no. Two things. One, it's a condition of employment. Like if you have a decent job offer, people will agree to follow all your safety and HR policies and procedures. So, it's a condition of employment. That's a contract. And secondly, it's also required by law. So right there, we got two really easy peasy slam dunks as to why people should comply, but ultimately we want them to go home safely. And then update. If you communicate to workers on a regular basis, right, start on training, but also have, meetings and that sort of thing, it's going to be really, really good for engagement as well. So some things that I've learned and things to share is that there really is a role of really good investigations and due diligence because it's going to help us find gaps in improvement opportunities. So it fits the whole spirit of having a health and safety management system where it's continuous improvement, and investigations are a huge part of that. Share findings as much as you can without breaking, privacy and confidentiality rules, but share your findings, implement changes with your workforce, right? They will have a natural curiosity as to what happened. Don't let them fill in the gaps to the story themselves, because then it'll just be rumors and assumptions. So it's really good just to give them critics to them. And really, it's helping build an organizational memory. So we're going to say, hey, you remember when? Oh, yeah, gosh, can you believe we did that? So you really move away from it and you progress and you evolve over time. Now, I know you've probably had this in the past with other providers, so I'm not going to spend a lot of time on this, but what happens if the ministry is coming? Well, if you know they're coming, be ready. Make sure that you have documents on hand. They're always going to want to see your safety board. They want to know who your safety rep is. They're going to want to see your safety minutes for joint health and safety. So just be prepared for that sort of thing, and be professional. They're there to do a job, and they don't like having to inspect you any more than you like having them there to inspect you. But they still are human and they're a professional. And with that said, they have some process to follow too. So I think that's important. And I always give this advice. And this comes from my auditing experience. In the world of auditing, there's a saying out there that is less is more. So you never answer more than what the question is. So don't expand, don't elaborate, don't hypothesize, don't give your opinion. Just answer the question. Do you have a health and safety policy? Yes. Where is it? On the board. Great. Don't expand on say, well, yeah, but the boss just updated it like 2 days ago because you were coming. Oh, really? Oh, all right. Well, what else can we find here today, friends? Right. And then they start looking over here and looking over there. This is actually, I laugh, but 2 weeks ago, I had a really, really, really big, heavy meeting with the lawyer who I'm working for with that fatality investigation, because their plant manager has been giving the Ministry of Labor information, telling them what to look for. Not helpful. Okay. We're not going to get into that. So, final takeaways, friends, as we're wrapping things up here. Stay proactive, not reactive. That's number one. You can't go backwards. You can't backdate stuff. Again, it's a snapshot in time. Due diligence is a daily practice. And legal updates are an opportunity for us to improve and reflect and talk and do a little networking as well. So that is my presentation, friends. Any questions or comments?
I think that this has been incredibly helpful and insightful, and certainly, yeah, if you stay ready, then you don't got to get ready, right? So, um,
Yeah.
any opportunities to be able to have a look ahead to make sure that there's no, proverbial tripping hazards, well, and literal, I guess too.
Then literal. Yeah.
To make sure that you have a clear path forward is certainly quite important. So, Lisa Ann, did you have any questions or anything as well?
I think for me too, one of the biggest takeaways for me is, and sometimes I forget because I get so busy, but the question is, are workers safe or are they trying to be safe, right? And sometimes I think I try to make them safe, but then I need to also remember to ask myself this question, like, are they safe or are they trying to be safe? And I think if I can remember that, then I can do a much better job at being proactive. So thank you for reminding me about that, because
Mm-hmm.
I had forgotten that little statement there. Um, yeah.
Well, and
And I like that the directors can now be fined because all this time, they never cared. But yes, they are in the firing seat now too. Nice.
They are, yeah. And I really do agree with that policy change. I don't know, Mike, if I told you what I'm expecting, but there's a very good chance I'm actually joining the policy branch at the Ministry of Labor in a couple of weeks from now. I'm waiting on an offer. If the offer is good, I'm going to accept it. It's a 1 year contract, but they want a little extra horsepower there. And it's really neat because I really believe that these fines and charges, yeah, that's a lot of money. But when you basically shut down a workplace, if you have, depending on the witnesses, you could have 10 witnesses, 20 witnesses, 30 witnesses, and you're going to go to court for 2 weeks. You're going to give the lawyers $100,000 by the time it's all done. And you still might get these big fines. Well, what's that going to change in that workplace? Potentially nothing. There's really no impact necessarily to that type of work, not that type of workplace, but that workplace to do training or have policies or procedures. Now they should, it would be in their best interest, but there's nothing that forces them to. So one thing that I'm really big about is allowing um, alternative sentencing or curative sentencing options that instead of the company paying, say, a $150,000 fine, that $150,000 gets earmarked for proper and adequate health and safety training policies and procedures and equipment that is then under monitor of, like, in an agreement with the Crown Attorney and the Ministry, and it's monitored over time. And if they become defunct or default, well, then it goes back to the initial charge. So I think there's ways to change things in the province for the better, not just throw money at people. And I should actually share this with you. Does anybody know where the money goes? So if there was a court case here in Woodstock, so let's say that there was a serious accident or fatality somewhere in Oxford County and it goes to the local courthouse here, where do the fines go when they collect them?
That's a really good question. I have no
Yeah,
idea.
tell
So
us.
in other provinces and territories, it goes back into the prevention system for WorkSafe BC or WorkSafe Alberta. Okay, and then they use it for resources and training, and that's what feeds the prevention system.
Oh,
But here it goes. So depending on whether or not it was on a county road or property or a city road or property, it goes back to the county or to the municipality. So in other words, they get pennies from heaven. It's like the casino when the casino has a, their quarterly profit and whatever their taxes there are. You go, here's your $150,000 for the quarter. It's just pennies from heaven. Now, there's a 25% victim surcharge that goes to the province, but that other money goes to the city of Woodstock or goes to the county of Oxford.
Interesting.
wow.
Wow. Wes, before we wrap up, can you tell us a bit more about Mazer Safety and how they can assist business, how you can assist businesses with opportunities? What can they reach out to you for?
Sure. Well, we do most of the health and safety courses that are kind of on the market. One being online WMIS is the only online course that we teach, but we're also approved to do Joint Health and Safety Committee Part 1 and Part 2. We do consulting, we do audits and inspections. When we say audits, we're talking small audits to large audits. We're also ISO 45001 certified auditors. And of course, as you know, we do investigations, but we also do supervisor training, help with orientations. And like we've got customers here, like right above us, Naughty Beauty, for an example. Well, we help them with the very basic things that they needed. Down the street at Whisk and Roll, we help them with the basic things that they needed. So yeah, so we kind of are a one-stop shop for things to do with health and safety. And to my understanding, really the only um, private employer or provider in those services here in Oxford. So
And if I had questions about maybe I don't know what it is I need, we can certainly anyone can reach out and ask these questions, and you can help provide some guidance and insight as to this is maybe something you might want to look into.
absolutely, initial get-togethers are always free.
Excellent. Well, that's been incredibly helpful, and what an incredible resource. It's nice to have you locally here, Wes. We certainly appreciate everything you do. Any last questions
Yeah.
before we wrap up?
No, I think this was really good. I learned a lot. Thank you so much.
Well, we
Super. Well, thanks for joining.
Of course. And I'll share before we say our goodbye, the Learn With Us series continues. We're going to be doing a workshop in the month of May, uh, presented po sorry, excuse me, presented by Burhane Immigration Settlement Services as well as Ladder HR. This is new immigration rules and what you can do to minimize potential labor impact. Lots of great opportunities to learn there. So keep an eye out. These sessions are recorded, so check out our resources page on the Woodstock Chamber website and see what other conversations have taken place. And by all means, certainly reach out if you have any questions. We'd be happy to connect you with both Mazer Safety or anyone else that might be able to help assist local businesses. Thank you again very much, Wes. We certainly appreciate
Thanks,
having you.
Mike.
And we wish you
Thank
all the
you.
luck with your opening store at the cheese shop and everything you do with Mazer Safety.